human rights violations, but basically the thing in common among them was they were all alleging a violation by the Turkish state security forces. Okay, so next slide. So what does this historical background say? In fact, the Turkish state authorities have long asserted that emergency governance or emergency laws were essential to combat the threat posed by the PKK. So I mean, the state of emergency practices were mainly grounded in terrorism. But at the same time, so when it comes to application of all these emergency powers, national security powers, so the state of emergency or the emergency laws were somehow coupled with oppressive political regime exercising arbitrary powers, because back then regional governments had all the state security, private and security sources under their command. So that basically gave rise to gravest human rights abuses against Kurdish people. Perhaps that's what I discussed to some extent in the paper. So a general or broader lesson maybe that we can draw from this historical perspective, whether they can create a precedent for future exigencies. So the thing is, where national security powers are piled up, the government, so that's based on practice, not just Turkish case but also the other cases. So the government will take it as a starting point. I mean, the already exercised emergency powers, they're gonna take it as a starting point rather than assessing the needs of a new challenges, because that was the case when it comes to temporary security zones in Turkey. So the state of emergency was lifted when the AKP government was elected in 2001. So then in 2007 the Turkish armed forces tried to adopt a different mechanism which is called temporary security zones. So what do? They basically enable the military to occupy the area and exercise powers similar to those under the state of emergency framework. For example, there was, I'm sure you remember, there was a peace process started in 2011 in Turkey. So that peace process collapsed in 2014-15. So starting from 2015, let's say 2015, so the PKK, started to fire again, or how can I put it? I mean, okay, started fire again. So I mean, they were basically trying to have some attacks. So more than 20 regions in the Kurdish Southeast were declared as temporary security zones. The legality of such zones is quite problematic because in 2007, that's that's really an interesting story. So Turkish armed forces only via their website declared that these regions will be declared as temporary security zones. When it comes to legal basis, it's just a law on prohibited zones. I don't remember the full title. It was adopted. That law was adopted in 1981 or something. So basically, there is no martial law in operation in Turkey. But with a broad interpretation, they are trying to exercise all those martial law-related emergency powers. But there is no declaration of state of emergency. Back then, there was not a declaration of state of emergency nor derogation. So let's turn back to the recent state of emergency. So that's the original notification I mentioned earlier. The derogation notification to the Council of Europe, lacks any details as to which articles of the convention would be subjected to derogation, but that would be understandable because that in the ICCPR regime, in fact, indeed states has to issue a formal derogation notice, or we can call it notification letter, notice, or letter. So that letter has to, include some derogation articles. But as in the whereas in the European Convention system, states don't have to do that basically, because I mean there was one case in the Greek case in 2081. So I don't want to bore you with that. Basically, I mean, even though the state of emergency, primarily justified by the coup attempt, when it comes to application, as the Turkish original notification to the Council of Europe or to the UN mentions, only touch upon all the terrorist acts. So all the measures can be applied to not only to FETÖ or Gülen movement, but also to other, terrorist organizations. And Turkey it was October 2016, I guess. Turkey sent a letter, or it was a memorandum. Yeah, it was a Turkish government memorandum. So PKK and Daesh, ISIS are the only other terrorist organizations. But so I'm closely following the application of the recent state of emergency, but I don't remember that any that Turkish state tried to justify any measure against ISIS related people. But that's the case for Gülen movement, and that's the case for PKK. But when it comes to ISIS, because the thing is, and we have to make a distinction here. The terrorism threat is not, the terrorism threat in Turkey is a domestic one. So it is a bit different than that we discussed terrorism throughout the workshop. Basically, we were discussing international terrorism against ISIS, but the state of emergency practice is chiefly focused on domestic terrorism. Accordingly, the Turkish state authorities are trying to adopt all the measures in a very broad counter-terrorism context. So, in fact, as the paper deals with the historical background, I had no time or no room to discuss all the specific measures. But a general overview of the post-coup measures, in fact, proves that we have, or the Turkish state authorities have reached an unprecedented level, targeting every and each economic, single, cultural rights, as well as civil political rights, through massive dismissals, extensive detentions, broad shutdowns, minority suppression countermeasures. Not surprising. The measures started to target Kurdish people, whether they can be regarded as a minority suppression countermeasure. I'm not sure, but I just put that in order to draw your attention, or anyone who's listening, us now. So basically, with these, broadly exercised emergency powers, and targeting every civil political rights, and Turkey is, indeed is, going to an authoritarian path. And this presidential system, or the switch in the, system in Turkey, as a society, I can say that we've come to a certain point that even the, Turkish state government is trying to reintroduce the death penalty. So that's the I guess the lowest point that any society can get. So I put some numbers together, and maybe you can take a look at them. So that is the outcome of the recent Turkish state of emergency. You see over 100,000 people dismissed from their public positions, and then more than 50,000 people arrested, more than 3,000 institutions were disbanded. Basically disbanded, even disbandment is not the right term. I'm not sure if liquidation is the right term. So they were basically closed down with all their assets. And when it comes to the debts of those institutions, one cannot put a motion to get the debt back. You know what I mean? It's not. It's not. Basically, so there is no legal expression for that. It's not a disbandment. It's not a liquidation. More than that. Well, I mean, to be honest, it's not just state mentality that we can blame. One also has to look at the contemporary derogation regime. So that is the Article 4 of ICCPR, and there is another article in the European Convention, Article 15, which basically premised upon the basic the same assumptions. The thing is, did I or I don't remember. So I guess I tried to discuss it elsewhere, not in this paper. But the thing is, so the two legal criteria or component of the contemporary derogation regime that constitute the heart of it is whether is one criterion is there must be a public emergency threatening the life of the nation, and the other one, all the measures, corresponding measures must be strictly required by the exigencies of the situation. So basically, contemporary derogation regime have some sort of a rule-like provisions and also some sort of a resilient standards. But when it comes to those two, key component of the derogationism, they seem to be, in fact, indeed, that's my point of view. They are not, a rule or hard rule. They seem to be some resilient, derogation standards. So basically, the question here that we should ask whether those criteria should be viewed as a delegation to national authorities or international tribunals. So another question whether for example the international regime or international commissions, human rights tribunals should take the primary responsibility to observe the compliance of these derogation norms. It's not clear. Because basically the thing is the emergency politics, of course I'm gonna do a legal analysis. Emergency politics is not within the scope of my broader project, but basically we have to understand that all the state of emergency, all the state of exception, including state of emergency, martial law, so they're basically premised upon the exceptionality. So in that sense, it is impossible to define the extent and variety of national exigencies, because derogation issues or the public emergencies are hard to define, and not just the presence of the presence of public emergency, but also the necessary measures to avoid such a threat. These questions that I mentioned now or ask somehow become much more relevant when you take a look at the state practice. Basically, emergency regimes tend to be accompanied by gross and systematic human rights abuses when states employ extraordinary powers to address threats to public order. That's the case in Turkey. That was the case in Turkey again, with regard to Turkish Saudis. I'm sure that is the case even though the state of emergency was lifted in France. That was the case. There were some critical opinions when it comes to the proportionality of the measures. But French case, I didn't study the French case, but at the fundamental level, the parliament does not, cannot adopt emergency decrees. That's the main difference, I guess. But whereas in Turkey, the Turkish parliament can adopt and rule through emergency decrees. Of course, we also have this, inconsistent and divergent international jurisprudence, which does not provide a guiding light for states. One highly complicated issue could be temporal element or temporariness. If you take a look at for example, General Comment 29 by Human Rights Committee, the state of emergency ought to be exceptional and temporary nature. But the thing is, when it comes to European practice has implicitly failed to acknowledge the fact that emergency regime should be temporary or exceptional. And that was the case in Turkey, for example, with respect to PKK, because I'm gonna mention now. So in Aksoy versus Turkey in 1996, for example, the ECHR acknowledged that in light of the material before it, of course that material is provided by a state, or in this case by the Turkish state. So the threat posed by PKK constituted a public emergency. But the thing is, emergency governance lasted in 15 years. So emergency regime, should be a temporary regime or exceptional regime, but at the same time we have this, divergent, somehow not, inconsistent European practice that allows the temporary governance that could, continue for many years. And that was the case in Ireland as well. And more recently in 2009 in A versus in A and others versus UK, and in fact the ECHR this time explicitly rejected the temporariness of the of such an emergency governance, because back then there was no threat. In that case, the ECHR, for example, accepted the UK government's assertion that threat to terrorism prior to any attack could constitute a public emergency. So the question whether the terrorism, be it international terrorism or domestic terrorism, should whether terrorism should constitute a public emergency. That's the main question. But when you take a look at the case of the ECHR basically accords substantial deference and wide margin of appreciation to national authorities, not just on the presence of the presence of the first criterion, which is public emergency threatening the life of the nation, but also on the necessary measures to respond to such a threat. So basically they are according a wide margin of appreciation on the proportionality of such measures. And then with regard to recent recent Turkish case study, I guess one important lesson to draw is the Article 13 ECHR effective remedies issue. So the thing is, I'm sure you're familiar with all this legal chaos in Turkey. How much time do I have now?
I'd say
five. Okay. So the thing is, I can be brief when it comes to this issue, because so there is only one more one more slides. So the thing is, under Article 148 of the Turkish constitutions, when there is an emergency decree, Turkish Constitutional Court cannot supervise that decree with regard to legality or constitutionality of such an emergency with the Turkish constitution. So that was the case for the constitutionality of the emergency decrees. But in fact in 1990 the Turkish Constitutional Court said that in two cases that they are not bound what the state or the state officials say as a emergency decree, they're not bound by the name of it. They're gonna take a look at the content. If they are in fact unproportionate to the threat, so they will not be bound this provision in the Turkish constitution. But as to the judicial review of emergency decrees in Turkey, it was a legal chaos. I mean, it was a total abdication. So they didn't perform any meaningful legal review when it comes to all these emergency measures. And there were some cases before the ECHR. Basically, all the applicants wanted to, did not want to exhaust domestic remedies because, according to them, the Turkish Constitutional Court or the Turkish Supreme Administrative Court or any other Turkish administrative, first ordinary court, they were not in position to provide a legal remedy or legal review for those, emergency decrees. But surprisingly, the ECHR found in every single cases that there was an effective remedy in Turkey. So there was no decision at all. For example, the Turkish Constitutional Court received more than 100,000 applications, through individual application mechanism, and they only decided till now in 2 cases, and both cases dealt with detention practices. So I mean, detention practice is not the only case. We have dismissals and all these broad shutdowns and stuff. So in June 2017, in Köksal case, again surprisingly, the ECHR found another remedy was available in Turkey. Since the Turkish courts, not just first ordinary courts but also Supreme Court, they were abducting or refraining from taking a position. So Venice Commission proposed to establish a commission, which is called the State of Inquiry Commission in Turkey. So basically that commission was adopted in January 2017 with a aim to provide some sort of a legal review, but it was adopted in January 2017, but it only started operating in July 2017. So in after 6 months, and only took some decisions in early January 2018. And basically, I guess they right now so far they took around 100 decisions. Basically, they simply rejected all the applications because the State of Emergency Commission was primarily tasked with providing a legal review for the dismissals. And if you're dismissed, or if you're a public servant dismissed from your position, you can lodge an application before them. They just simply there is no oral hearing, so there is some problems when it comes to fair trial requirements and stuff. So they basically took some reports from Turkish intelligence agencies or any other state officials or organizations or departments, and they simply rejected all the or vast majority of the applications. And then one final I mentioned this before. A coup attempt could constitute in fact as a public emergency, but when it comes to all these post-coup measures in Turkey, they basically seem to fail the proportionality test. I'm sure the ECHR will their hands full in coming years. Okay, basically this was my conclusion. Thank you.
Thank you. So, çok teşekkürler Emre. That was a very full paper. When I was reading it, I have to make not a disclaimer, but to say that recently I have been also appointed in the International Law Association in this new Committee on Human Rights in Times of Emergency, and I'm assigned Turkey. Okay. So I'm working a lot on Turkey to report on Turkey and state of emergency. So I have to say thank you. Thank you. This is the very first time that I see a paper full of information. So I have several comments. And I have general comments and more special comments. Okay, and I know
Happy-
that
happy to hear
you're in. I know that you're in the process of the PhD, and usually, you know, when we write our PhD and then we write a paper, we try not we try we do it automatically. We try to put everything, you know, in one paper. So I think your paper is so dense and so full that it could be 5 different papers.
Yeah.
Okay, totally 5 different papers. You have all the information, you have the capacity, you have the knowledge. It just I would like a little bit to challenge you, to push you, if it's okay with you. So when you were presenting, you say, I will try to conceptualize the Turkish case, you know, and also you say, I have a critique, but it's a modest critique. Okay, I would say you should not remain into the modest critique, but push yourself, you know, because you have the potential here. And while I was reading your paper, the same time I was reading the report by the UN Special Rapporteur on Counterterrorism and Human Rights, Fionnuala, Professor Fionnuala, how is Neoline? The Irish professor, who just submitted her report last week before the Human Rights Council. I will send it to you. You know, this is a wonderful report, and I thought that your paper, you know, I was reading your paper together with the report by the Special Rapporteur. It's her new mandate actually, and. I realized, you know, that the points she clarified could very much fit into how you could work with this information and paper you have here. So you can do several things. One thing could be like to remain which is fine. I'm not saying it's not fine. To stay with the descriptive, you know, you do, I'm telling you, it's a massive task what you do to provide us with all these this full information that we don't have because we are not native speakers, you know, and we cannot follow. So you give us a wonderful descriptive component, you know, you give us a historical component of the state of emergency, and then you know, you can further work on this descriptive and update, you know, with some comments. The other way, and this is where I would incline, but this is again my feeling, is to explain why Turkey is different. And you do that. It's all over the place, you know. You hint on that, you know. But you hint on that during the last paragraph of every chapter. And I would like to see more your voice, you know, because you know the topic. So you can write this descriptive analysis, you know, on your PhD. You do that, you know, you explain. But I think this is a wonderful opportunity for you, you know, to raise your voice and to say, why is it different? This is a feedback I got from a paper, and they told me, why is it different what you claim, you know? So I think it's very, and Turkey is a different case. It is a different case. I remember, you know, when the Turkish state of emergency was declared, first of all, I was in Turkey when it was declared, and I think that afterwards there was a meeting with the French Minister of Foreign Affairs. And
in Turkey?
I don't know if it was in Turkey or it was in Europe somewhere, you know, but it was like the Turkish Prime Minister or Minister of Foreign Affairs and the French one. And the Turkish official said, I don't see your problem. France has a state of emergency, so why do you criticize Turkey? Well, and this is, I think, where lies, you know, your key argument, you know, that Turkey is an exceptional case within all the exceptionalities. Okay, so I think this is something maybe that you should have in your mind as a point of reference, you know, that you want to show, and you do that. I will continue. So as I say, there are lots of dense arguments over there. I very much liked all these arguments, you know, like your conclusion, for example, for me, okay, yes, I think it's a very clear-cut case that we go beyond the proportionality test, blah, 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 sorry, I don't want to say blah, 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 but I'm saying, you know, that everything, yeah, legally speaking, we have a problem. This is clear-cut case. The thing is, what lays underneath, okay? So your first argument that there is a pertinent problem of the political context, you know, and that we should not isolate the Turkish case out of the political context. I think it's so important, you know, and this is a very key argument. And you hint at that when you say, for example, that the European Court of Human Rights, when they identified violations, you know, of human rights and the state of emergency in the 90s, actually and Axal, maybe they said, oh yes, the defendant, there was a problem, but they didn't touch on the context, on the pattern, the pattern. And this is, I think, it's a very key issue. And how is that? How can we tie that with what the UN Special Rapporteur on Counterterrorism is? I found very interesting her latest report because it talks about the normalization of exception. And this is a clear case in Turkey, that gradually, not only from 1920s, but let's take the period from 1978, okay? The first thing, gradually these emergency laws have been integrated in the domestic legal body of Turkey. So when we had the new emergency laws, as you say that today, you didn't start from scratch, but they piled up. So already, we have the erosion of the normality of the domestic legal system gradually in Turkey. And I think this is a key difference with France, for example, with other state of emergencies. When we have the new normality, which is the normalization of exceptionality, and you make that claim. And I think that this claim should be there in a more forceful way. Do you understand what I mean? Okay. And this is, of course, where you make the reference for the wide margin of appreciation. You said we had a problem there. You touch a little bit about that, but I think that it's fine at this stage. If you make your voice more clear and not be modest, but say, I think there is a problem there. The European Court of Human Rights totally missed this detail, which is not a detail, and now we see that after 30, 40 years, how we end up in 2018, that we have already a state of emergency legal mentality, which is heavily established within the domestic legal Turkish system. And I think that shows one of the exceptionalities of the Turkish legal system, okay? The second point I would like to make is, what about the Turkish judiciary? I think it was absent, from the paper so far, apart from here at the end, when you talk about the inquiry, it's called the Inquiry Commission, We know that the Turkish judiciary has a massive problem, We cannot say that it abides by the rule of law, abides by the rule of law standards. So the current state of emergency, but even, I don't know, maybe you can claim that it was again a gradual process, From one side we have this state of emergency laws, that they have been integrated in the domestic legal system, and to what extent parallelly we have an erosion, of the independence and impartiality of the judiciary in Turkey. Because yes, of course, we have an inquiry of commission. We know the attacks against the Constitutional Court, and more recently, last week, 2 weeks ago, we know, for example, that a judgment by the Constitutional Court about the release of two journalists has not been.
But that's a bit problematic. But I can.
I would be happy to hear your comments on that. Still, I think that the context does matter, and it's a very different. These are 2 points, that you should highlight. And maybe, there this is my understanding, that you say the exceptionality, is an exceptionality which is a normal exceptionality in Turkey for decades, okay, for decades. So please, the Fionulla's report, I will send it to you because it talks about de facto state of emergencies and hidden state of emergencies, and this is something very useful for your arguments, because I think it describes quite well. It's a short report, but it describes quite well, and especially this thing when the state of emergencies have been integrated in the domestic legal system, and we take it for granted. It's the new normal, and this is maybe new for some countries, but not new for Turkey. Okay, and you have touched upon these issues. Okay, I have. Another thing which I consider very important is also you refer to the Constitution of 1982. Of course, your Constitution have been amended, but again, the state of emergency in Turkey, or the stage of emergency, should be analyzed in the context of the Huda Constitution. Was it the Evren Constitution, the 1982?
I mean, it was a military.
Yeah, it was a military constitution. How this constitution has changed, to what extent it has changed, or to what extent it has accommodated actually, the state of the laws of the state of emergency, plus, as you say, the change or your system to a presidential system, you know, and how that, as I say, accommodates further, you know, the easiness. Something else which is very interesting for Turkey, and I didn't know, is the difference between the state of emergency and martial laws. And somewhere you say in your presentation, I want to focus only on the civilian state of emergency. But when I was trying to understand it, I was asking Turkish colleagues and friends who were like, "Oh, it's so confusing."
It is.
And it's so confusing. But this is something wonderful for you, you know, to try to see, okay, why is it so confusing? What does it mean that it's so confusing? And again, you know, we go into the hidden state of emergencies, you know, into the de facto state of emergencies. And I don't know. I ask the question for you. To what extent, you know, the martial laws and the state of emergency, if there's something else there, you know, and
bonds.
exactly, and to what extent, you know, because we have prolonged periods, you know, of martial laws and state of emergency, especially southeastern Turkey, and all this indicates that it appears that there is a legalistic mentality, okay, if we can say, you know, that is very heavily founded on that, okay? That's some of the observation. The minority rights, you said, there, it's another paper, but it's super interesting. When you mention, I say, oh, no. I mean, I can tell you, you know, you can have 5 different papers there.
One whole volume?
Yes, yes, of course, but you can write that as different chapters in your PhD, you know. But when you have an article paper, then focus on that. And I think maybe a suggestion, you don't have to go there, you know, maybe a suggestion is to say, why is it? Because, you know, to read that, you know, everything is, there is a problem with, we know, we know, we have the Venice, we know, we have all these reports, there are more reports coming, we know that there is a problem. But to what extent, you know, this is a problem that pre-existed, you know, and now has been further accelerating, you're in a unique position, you know, to do that. Okay, some more can I give some more comments, feedback there on the paper? So for example, you know, like organizational, I know you told me, you know, that it's a rough paper, you know, but it's a rough, not so rough paper. I thought that it was very sophisticated rough paper. So basically the introduction for me, you know, it should be much smaller. Of course, you know, you don't need to put all this information there. Then it's something I learned in Israel. When I make a claim, I have to substantiate this claim, you know, especially in my footnotes. So you make 2 very strong claims in the first page.
Introduction, I mean,
in the introduction, you make very strong, very forceful claims. And then I was checking the footnotes. I was this gig checking the footnotes, and I was like, really? Okay. So, for example, you say at the end, the executive branches have been traditionally placed, you know, in a favorable position, blah, blah, blah. Okay. And then you have one or two, you know, when you claim, either you take out traditionally, and I'm telling you as a geek now that I'm trying to save you from critique, you know.
Good.
Geek or Greek?
Geek. No. Ha. That was I thought that she was going to say, Maria, no. This is no. But it's not only that, it's important, you know, like the choice of words, we don't realize. I mean, I do the same thing, you know, I write something and I say definitely, and then I get this critique, why definitely? So I'm trying to protect you here, you know.
That's good, but you don't believe that, you know, the executive branches are placed in a favorable position traditionally to, you know, respond to such emergencies? Is that the case? Or should be the you know, judiciary? Or?
I would like more sources.
You would like more sources?
I would like more sources.
Okay.
This is something, you know, I would like more sources, because when we make a strong claim,
but the thing is,
can I? Just take that. And also, you know, I know that you are familiar with all the scholarship, most likely more familiar, definitely than me, from all the scholarship. But there are some recent books. I mean, not so recent. You know, there's a book by Professor Noren Gross and Fionulas, which is human rights. Law in time of crisis, right?
2006.
6. It was after
2000
September
so-
11th, yeah, 2006.
2006.
And there is a current editing volume by 2016 of Macruden, Human Rights in Times of Emergency, where Fionnuala...
The Red Book.
The
No,
Red
I
Book, and we will produce reports from the ILA, blah, blah, blah. So, of course, there is, but especially because Fionnuala is an academic who has worked a lot on that, it's a great source of inspiration. And I think it's one of these mandates where the mandate person, the special rapporteur, knows a lot what he's talking about, So
I think she was chosen, wisely.
yeah, I think it's a wonderful appointment. So having said that, for example, I say from here, like in page 3, if I would like an introduction, I would go right to the point, like to say, and to make, according to the arguments you decide to make at the end, I'm going to do this. So you could have a page and a half in introduction. And I know this is a very difficult exercise when you have all this information and you want to put everything there, but this is the fine balance that you have to do as a scholar. Then part 2, and I'm talking about the current structure. Part 2, I understand you want to give the historical background, and this is very important also if you go for the claim that there is a pattern. There was this pattern. We cannot check the state of emergency in Turkey isolatedly, from the historical pattern. It's very important. Yes, I agree. Where I was a little bit, I felt that to some extent there was a brief duplication, It was when you started part 3, where of course you wanted to focus on the current stuff between 1987, and what. But of course there were some elements, that they were repeated already, in that. And this is something, you see, parts, how do they work together? So this is something, you have to find. But I would say, yes, the historical context is important, the doctrinal context is important, the descriptive context is important, but your comments are more important, So how your comments come out of that. Blah, 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 blah. Yeah, here is, yes, the argument. Also maybe somewhere, I say the trials of disappeared, that they take place now in Ankara. Not now.
Forced disappearance?
Yeah, of the early 90s, that it was a period, which is quite interesting, that it seemed to have a revival of this reconciliation. Also the idea, that we have to deal with the past, and we have extensive, as you say from the Amnesty, extensive enforced disappearance, torture and enforced disappearance in the late 90s. And maybe there, you can also find something. What's going on now with those trials? Do they
link to the current?
Yes, to link to the. Do they move? Have they changed? Have they stopped? I don't know.
There's some state practice.
Yes, yeah, but that's something that maybe it could be of interest. And then, as I said before, every time when you were finishing a chapter, I was like, yes, this is the argument, But I thought it was a conclusionary argument, whereas your argument should be throughout the chapter, okay? So don't be, I wouldn't say afraid, but you understand what I'm saying. Don't be, and you should be modest, okay? When I say modest, yes, you should be modest, but try to you have strong points there, but we have to look for these points, like the same applies also and something else I'm going to say also here also I say at the end, I have your argument, there is always the argument, and then you have a small conclusion, but your conclusion is everything. It's so dense, in your conclusion I see all your different arguments, your own arguments, and I would say that these arguments, take this conclusion, print it separately, and say, how am I going to, I have 4 arguments here, or 5 arguments, how am I going to incorporate these 4 arguments in the previous pages? And I think you have something great. I mean it here. 2 more comments, okay?
Please.
Okay, can I? 2 more comments. When Ido told me, Maria, we will have a paper on Turkey, I was thinking, I'm going to read Schmidt, I'm going to read Gagaben, I'm going to read Hannah Arendt, and I was thinking, there is nothing there. Nope, which is okay, more than okay. But I was wondering, this is whether you consider of incorporating some conceptual work into your legal analysis or not, or maybe you're going to do it somewhere else, which is again totally fine. But I'm thinking every time I hear of Turkey, I'm thinking that Turkey is in a permanent state of emergency. And you are in what? In the sixth time that it has been renewed, the state of emergency? Fourth time. Okay. Children. How many times?
50 years.
Okay, good, cool. Okay, yeah. You see, you're children. You have more too. Yeah, but yeah. Yeah, but if we think a little bit of this permanent, I think maybe a title would be a permanent Turkish of state of emergency, because it feels that it's there. It was always there. It's just that we realized after the coup d'etat, because it affected broader people, more people, okay? But it was there. So I don't know to what extent Agamben and Schmidt would fit, but maybe you should keep that in mind if you want. And I'm done. Thank you. Thanks.
You said you had two more comments, but
the two more comments was the permanent state of emergency, and then the lack, not lack, that I didn't see the usual Schmidt reference, that everybody talks about Schmidt. Although, can I say that I read that I only now discovered that the most interesting, one equally interesting scholar of that period was Hermann Heller, another German legal jurist that you usually don't know the non-German speakers, because he has not very widely who responded to Schmidt a lot, Hermann Heller. So it's very trendy. All of us talk about Schmidt, but maybe we can check the other side. Okay, so.
Can I just take 5 minutes to respond? Yeah. Okay. When you said that the article is not focused enough or is not concise, so that's true, because the idea of this paper, as I told you, was to deal with the historical background. I mean, basically this is an ambitious project.
Yes.
I mean, if one wants to conceptualize all the ways, all the means. And I mean, it's just not a topic for one article. It's just maybe a topic for 5 articles or a book or a volume. So that's not easy. And when it comes to the content of paper, to be honest, that's not even a draft paper. That was a collection of already drafted parts.
Okay.
So I mean, because that's why it's.
But Emre, there is no inconsistency. It's not lack of coherence. If it's a collection of drafts, that's a big task, a very successful task.
Okay.
Because I didn't feel that it was incoherent. I just felt that it was too much. You understand? Okay, so
because when I was writing my chapter of my PhD dissertation on this circle aspect, so I took a pause somehow. So I mean, there is this pattern. I mean, you're definitely right. But when it comes to, for example, reading all these materials related to Agamben or Schmidt, I mean, that would make total sense. But the thing is, I'm gonna provide a legal analysis of the measures. I'm not sure, because the thing is, when it comes to emergency politics, it's so hard. It's really hard. I mean, so the thing is, I'm not gonna go with Schmidt, say that to declaring a state of emergency is a sovereign right of a state. That's not the case. Basically, how I see contemporary derogation regime, of course, there is some distortion somehow. Or I mean, one has to critically analyze the fallacies of the contemporary derogation regime, but derogation regime is one regime of rule of law. I mean, it's not a leeway for states. Eventually, if a state declares a state of emergency, they will be bound by their measures. Whether I mean, they will be given a chance to provide a justification for those measures. If that's not the case, so an international human rights tribunal, let's say ECHR, will find a state, violating the convention, for example. So derogation regime, the legal aspect of derogationism, I thought it's more than enough for me to focus on. But I totally agree that maybe I should, read more on Agamben and Schmidt. But whether I should do that, I should do that. I should read, but how to what extent I should focus on Agamben or Schmidt? Because I mean, I'm coming from a law background, and the main methodology of my PhD is legal positives methodology. So I will definitely read more.
You don't have to make it a philosophical PhD, but I'm saying that
Yeah,
maybe
when it comes to conceptualizing of something of course you're right. So I have to read, but the thing is, I wanted this paper to to be sufficiently in legal nature. That's why I felt no need to discuss descriptive. Yeah, definitely. I totally believe that the paper is quite unripe now. So explain why Turkey is different. If we take a broader approach to analyze the Turkish issue, Turkey is quite exceptional, quite a peculiar case. You're right, because I mean I don't remember any state has taken measures as drastic as Turkey has done in the recent period. I mean, see, more than 50,000 people arrested on alleged, affiliation with of a terrorist organization or so-called terrorist organization. I mean, that's not the case in France, for example. Of course, Turkish case is different, but whether I like to deal with Turkish exceptionalism, which is so complicated, so hard to understand, because it's everywhere, not just when it comes to the application of state of emergency practice. Even in a decision of a first ordinary court, it's there. Yeah. It's there. Turkish exceptionalism, like an American exceptionalism, like or maybe we can, it bears great resemblance to the Israeli case to some extent. So what lies underneath? It's hard to define, but I will definitely take a broader approach or broader perspective to, of course, political context. That is something might be something useful, but the thing is, I mean, the political atmosphere is in Turkey, of course, reflects a pattern. For example, when it comes to Gülen movement, I know you know them. The thing is, they used to operate legally, peacefully. They were part of state Turkish society, and in 2013 you remember all this embezzlement and bribe allegations, and the Turkish state official, let's say, but I mean in particular President Erdogan, declared them, the Gülen movement was behind this embezzlement and and bribery probe, and then there was this political tension between them. I'm sure that political tension has its some precedents in 2011. I don't know, but the point that it got to a surface. So that was that embezzlement and bribery cases. So starting from 2013, I'm sure President Erdogan was accusing Gülen movement of everything. If if it snows hard, so they are the behind of it. If there is a tornado in Turkey, so they are the behind of it. So then I guess I don't know how he did that, but he I guess provided or presented a convincing argument before the National Security Council in 2015, and that council, which is a part of the Turkish armed forces, so they declared FETÖ organization a terrorist organization. So they're basically place. So if you take a look at the policy of Turkish state, so FETÖ is number one, PKK is number two, and now I guess we can come to conclusion that PKK is a terrorist organization. Whether declaration or declaring PKK as a terrorist organization, whether it's a legal or political issue, it's of course open to criticism. But FETÖ, I mean, Gülen movement, a religious card, they are still in Europe, for example, and European Union, for example, did not declare them as a terrorist organization. So when it comes to political context, what I mean, there is so much to take into account.
Yeah,
of course, that's important, but that's why my focus is on the derogation, which is the official or legal name of a state of emergency. If a state does not declare or does not, for example, issue an official notification to the Council of Europe of its intention to derogate from some rights, that's de facto state of emergency. But when it comes to analyzing them, we can only analyze the consequences of such a state of emergency. But when it comes to legal analysis, it's hard to.
But Emre, I'm not suggesting not to do a legal. I mean, I'm a lawyer myself. Okay, I'm not suggesting not to do a legal writing here. And when I say about the political context, I'm saying that law does not work in a vacuum. First. This is my first comment that you have, and I didn't and it was not only about FETÖ, whatever it's called, it was something that you try to indicate in your paper. You say we from 1923, we have all these states of emergency, and especially after 1978. And you at the end of the conclusion you say we see that the worst violations take place under state of emergency, targeting the southeastern Turkey, where predominantly is occupied by the Kurdish population. So when I talked about the political context, I meant to how you analyze the legal developments within the political context. And for me, a key legal development also, I think, maybe you want to respond to that, I'm not telling you give me the political context behind that. We're lawyers, we don't know everything, we can sense, but we don't know, and this is not your scope, and this is not your task. You are a lawyer. But also we cannot hide behind legalistic things. I declare a state of emergency, I take it from there. And this is why the report by Professor Niolan is so important, speaking of hidden state of emergencies, of de facto state of emergencies, where we have a period, where we may not have a legal declaration, but still we have a state of emergency, and this is a characteristic thing. Another thing, the judiciary. I insist in that. I think it's a key issue, and maybe you want to comment on that.
I will. Margin of appreciation, erosion of the democracy. What I learned, I guess, from the research of this paper, especially with regard to Turkish state of emergency cases. When a state, I told you during the presentation, when a state uses these extraordinary national emergency powers, and they are piled up, and they tend to create a precedent. So that's for sure. It's like, so the government basically take it as a starting point. They're not, so as you said, this emergency powers, that emergency powers are getting a state or a government to some place, and then the next time the government starts from that point. So it's like a heavily used medication. In order to have the same level relief, you have to increase the dosage to create the same relief. Basically, that holds true when it comes to national emergency powers. So erosion of democracy. Okay, yeah, that's a pattern. That's Turkey. When it comes to Turkish judiciary, so the fact that I didn't focus that much, because back then we had state security courts, which was abolished in 2004. So those state security courts were basically established to try anyone whose activities constitute a threat to the Turkish state and Turkish constitutional order. So the thing is, and when you take a look at the legal operation of Turkish emergency powers, In 1990, Turkey sent another letter to Council of Europe, and Turkey informed the Council of Europe to derogate only from Article 5, and that was in especially in relation to the proceedings before the State Security Courts, because back then, in for example, in relation to individual offense, so detention period is 48 hours, and if it's
14 days.
and if it's a collective offense, as in the kind of a terrorist organization, I said it was 14 days. So, but the State Security Court somehow provided longer detention periods. If it's a collective defense, that was 14 days, and if it's an individual offense, 14 days, and if it's a collective defense, 30 days. And in the Aksoy case, for example, the ECHR found Turkey violated Article 5 because Turkey held suspect in 14 days without judicial intervention. So, but since then, Turkey was trying to be a member of the European Union, and the state security courts were abolished in 2004, including the death penalty, for example. But of course, when I make this point that this state of emergency powers are piled up, of course the Turkish judiciary or any judiciary takes its toll on that. So that's basically related to the Turkish exceptionalism. The content. Okay. When it comes to the recent case by the Turkish Constitutional Court, I think under Turkish Constitution, so the first ordinary courts are liable by the decisions of the TCC, Turkish Constitutional Court. But from my point of view, they are not bound by the content of the decision, because basically, in that case there were two journalists, Mehmet Altan and Ahmet Altan. So they lodged an individual application to the Turkish Constitutional Court, and when taking a decision, the Turkish Constitutional Court basically ruled that this was not a proportionate proportional measure. So then asked the first ordinary court to release them. But the first ordinary court that was in Istanbul, so declined to obey the TCC somehow. But if you take a look at the decision of the first ordinary court, I think they might be right. Yeah. They can either release the detainees, or they can review the grounds for detention, and if they provide another reasoning, they can put them in prison.
Sorry to interrupt again. So, I agree.
So I'm from a legal perspective.
But this is what I'm trying to push you to work under the not even legalistic. There is a commentary by Basak Chali at Heritage School. You can go in the Verfassung blog. It's about this decision,
I do remember. I read,
and Basak says so. Actually, the first instance court, and I don't want to go into further details, but basically applied an extremely legalistic interpretation in order not. But I'm not focusing on that thing. I try a little bit. I persist on the judiciary, because it's a different thing to have a state of emergency in France. Okay, and it's a different thing to have a state of emergency in Turkey, where you don't have an independent judiciary, where you know that your exercise, your right, to an effective remedy is a joke, simple like that, So I think it's very important. But that's, again, I don't want to press you to go into that direction. But I think it's not a parameter in the periphery. I think it's part of the core of your argument. How is the state of emergency working in Turkey? And whether civilians, common people feel safe that if there is a separation of powers, and that if they go before an independent court, you know, the independent court is going to protect them, you know, from the arbitrary exercise of the executive power. And this is something, you know, okay, setting aside this case, leave this case, you know, aside. I don't know, I mean, I'm not an expert in Turkish constitutional law, okay? Set aside this case. Also, there is a very recent resolution, which is, okay, the European Parliament, who cares about the European Parliament? We are online, but still, my point is that there is a resolution by the European Parliament, you know, where, and of course by the Venice Commission on the rule of law and the state of the judiciary in Turkey. And
now you're turning mute.
Yeah, and this is but this is a key issue, and this was a key issue before the last state of emergency. You know, the state of the judiciary. Okay, I mean, we see United States. Okay, we are not happy, but at least there is something still there, you know. We have faith most of the times in the courts, you know, that the checks and balances will work out. The same used to apply for Israel. I don't know how is the situation now, but you feel, you know, that at least there is a judiciary where the last resort. Yeah, okay. Anyway, some time ago, you know, you felt that there was another level of protection. You know? So anyway, just keep that in mind, you know, that it's because of course the judiciary is intervened with all the individual applications, you know, it's last resort. And when your constitutional court is attacked, or when you have the inquiry, I mean
attacks on Turkish constitution are legion. I mean,
it was a legion, exactly. It was a human rights court, the Turkish constitutional court.
Two more points, maybe. You know, when it comes to martial law and state of emergency under Turkish constitutional framework. I mean, martial law is as I told you, is different. I mean, state of emergency regarded to be a civil, and they basically mean less severe interferences when it comes to human rights. But martial law, basically, Turkish Parliament in fact declare martial law, as in the case of, you know, state of emergency. But when Turkish Parliament declares martial law, only, you know, martial codes are, you know, will be in operation, let's say. So I'm not an expert on that topic, and we have really, you know, extensive legal codes on that side. They're still in effect. When it comes to, you know, the introduction part, it is quite lengthy. So the thing is, what I was trying to understand in that part when I was writing that part. So the thing is, terrorism and state of emergency, whether terrorism constitutes a public emergency, or what's the threshold, what's the criteria for that. I mean, even, you know, not just, you know, in a post 9/11 era, but also before maybe, and also, I mean, after. I mean, in 2009 there was this case by the ECHRA and others versus UK, and there was no attack in UK, and I mean, still. So the thing is, why states, that was the question I was trying to ask and understand, why states declare state of emergency, because they at the same time have all this ordinary legislation, which many extraordinary powers have already been transformed into ordinary legislation. Whether if they want to, for example, adopt another code, whether that code necessitate a derogation, it's not clear, especially when it comes to the extraterritoriality application. Whether British, you know, derogation in those, you know, operations, whether it requires a derogation or not. So that was I was trying to, you know, ask and understand. But it is, you know, quite long, and I will definitely, you know, I honestly believe that the paper should be polished extensively. But I mean, the way you respond, I think I'm gonna somehow review my decision. I'm just gonna, you know, stick with this circle background, not, you know, try to conceptualize or something. Okay.
Okay.
That's all I do. Thank you.
We don't have much time. I think Maria is taking most of our time. Actually, it's started late now.
She started late.
That's
Very good.
And I
Well,
think
it's Barbara's
perfect.
fault and she went.
Barbara has to take responsibility for us being late.
and not for that IT guy. No.
IT/DJ.
No. IT/DJ. Yeah, no.
Don't keep the DJ.
Don't mess.
Thank you, Emily.
Thank you.
Thanks a lot. Sorry for that.